Hello, good afternoon. I'm Dr. James Gilley, and this is American National Government. In this module, we're going to be looking at the judiciary and our civil liberties, our rights. Where do they come from? Right? What do they mean? Right? What do we have? What's guaranteed by the Constitution? This is going to be the final module that covers our 3-episode or module character arc, examining the institutions created by our Constitution. Right, the institutions that govern and make up and interact and create the government that we have here in America. So let's just go ahead and jump right on in and see where these things come from. So examining Article 3 of the Constitution, we see where we get our federal judiciary. Right, so Article 3 of the Constitution creates a federal judiciary, but it creates it only a small sliver of it. Right, the Supreme Court is the only thing that's actually created by the Constitution, and the Supreme Court doesn't even have a certain number limit that's put in there. Right, the 9 justices on our Supreme Court's actually more of a tradition than anything. Right, so when it comes to the federally created courts, right, mandated by our Constitution, the only thing that's actually in Article 3 is a Supreme Court. In the rest of our courts, right, the rest of the federal judiciary that gets created, that actually comes from a power granted to Congress in Article 2. So the federal courts that we have, right, the court system at the federal level, right, not state courts, it's dictated by Congress and in some ways established by Article 3 of the Constitution, but is everything below the Supreme Court is predominantly done by Congress. So what we see is that at the federal level, right, in these federal courts, the judges, the people that are actually making the decisions, right, also the U.S. attorneys and all of the Justice Department and justice things within our government, that's created by appointment. Right, so all federal judges are going to be appointed. Now, at state levels, this can vary wildly between states. Some states, like Louisiana, right, where I am right now, are much more predicated on electing judges, but at the federal level, they're appointed by the president, right? And then Congress has the ability to go in and approve or disapprove of the appointment, right? That rolls in. So these judges appointed at the federal level really make up the entire system. And what we see is that the system as created by Congress is made up of 94 what we call district courts. And in these districts, right, these are kind of that frontline basic level of federal court, right? This is where you would go, say, if you were declaring bankruptcy, or if you violated some sort of federal law, or if you're trying to sue the government for something, you would go to one of these 94 district courts. Now, I'm sitting here in Thibodeau right now, so there's probably an equal chance I'd be either given to New Orleans or Baton Rouge, the districts there. Those are the closest ones. And these 94 district courts are kind of distributed, sprinkled across the country in order to carry out the work of a federal judiciary, right, of the judiciary at the federal level. All right, so that's your basic level. That's like bottom tier, 94 of these district courts. Now, if you win or lose at that level, right, you could get possibly bumped up to the next level, right, level 2. Right, these are the appeals courts, right? We call them the circuit courts of appeals. And I know it looks a little weird up there the way I wrote 13, right, as 11 plus 1 plus 1. But that's actually much more the reality of what's going on. There are 11 circuit courts of appeals across the United States. Excuse me. Caffeine wall. Right, there are 11 of these circuit courts of appeals in the United States. And these are where most cases get referred to for repeal up from the district courts. The next plus 1 on that is the D.C. Circuit Court of Appeals, because Washington, D.C. Is its own federalized jurisdiction, right? It gets to govern itself. So that D.C. court really serves to serve as a court of appeals for Washington, D.C. itself. And then up one, right, and then that other plus 1 is what we call the Federal Circuit Court of Appeals, and that's for actually internal governmental issues, right? If they need to have an appeal or a court ruling, they go to that district. Right, and so out of those 13 courts of appeals, right? If something gets kicked up one more level, that's where Article 3 is going to kick in. Article 3 of the Constitution kicks in, and we get to the Supreme Court. There is one Supreme Court, the highest court in the land, which also, interestingly enough, that's what they call their basketball court. Those justices, they're punny, right? This Supreme Court, right, is the ultimate arbiter of legal and judicial matters in the United States, right? And it's a very generalist court. It does constitutional matters, criminal matters, civil matters, and we'll kind of break that down in just a second, what all those differences are. So in the United States, we have a couple of different types of law, right? We've really siloed off our legal system into two separate bits. On the one hand, we have our civil courts, right? This is where there are claims and disputes between citizens, right? If you're suing someone or being sued, that's going to be carried out in what we call the civil court system, right? It's based on a process called torts, or turning the law against other people. This is a system that's much more predicated on right, plaintiffs and defendants, right? This is right, citizens against citizens, or citizens against the government. On the other hand, right, the other side of this, the criminal law system, right, that is the system that, right, you watch Law and Order, and right, that's what's going on there. Right, this is a system, right, that's the part of the legal system where the state is the prosecutor, and right, they are always claiming something against individuals or groups or companies or whatever. But that's where crime actually happens, where the state serves in this role as a prosecution. Now, our overall legal system is based on something called the adversarial system, right? It's this notion that arguing court cases really helps breed fairness and justice throughout the system. So it's only through, right, arguing against each other in front of a judge or a jury that we're able to get to the most fair outcome, right? This is opposed to like trial by combat, where you hire someone from Dorne to avenge his sister, right, to prove that you're innocent. Game of Thrones reference. It's up there. Game of Thrones reference. Right. This adversarial system is really what really modern law is predicated on, even in both the civil and criminal portions. So if you're in the criminal portion, right, it's always going to look like prosecution versus defendant, right? Those are the adversaries there. The person saying you did something wrong, the person saying no, he's innocent. Generally speaking, it's the state that fills this prosecution role, whereas defendants can kind of wildly vary. And what we see is that due to the volume of things going in the system and the ability of the state to push its power in the system, sorry, I got yawns. Right, we see a lot of things called plea bargains, where the people that are being prosecuted say, okay, I'll admit that I did something, and the prosecution will really lower the threshold there. Like if you've ever gotten a speeding ticket and they've lowered it down to like you weren't wearing your seatbelt, that's actually a plea deal. Right? That actually was you saying, I'll say I did something else, I'll pay my fine, and you'll let me off of the bigger crime. Right, so that's really the way that system, this legal system, functions, right? At least on the criminal side. I'm so sorry, y'all. I don't know where these yawns are coming from, right? But what we see is that, on the other hand, plaintiffs sue to try the justice of the law itself. On the civil side, right, you can actually claim that the law itself is unjust when you're suing the government, and right, seek recourse or redress of your grievances in that manner. So the real important thing to know here is when we're talking about criminal law, we're talking about the state prosecuting you for having done something wrong. On the other hand, the civil law system is about different claims between citizens, disputes between citizens themselves, or between the states, right, between the state and the citizen, or between the states as well. So civil law handles, right, disputes about interpretation. Criminal law is about you did something wrong, right? There's actually a law that says you can't do that, and you screwed up, so you're in trouble. So let's take a little bit of a deeper look here. Right? How do we go about actually making our judges within the system? Right? How do we actually get judges? Right? So what's important to look at here is that the president at the federal level No matter if it's your basic U.S. attorney or district judge, if it's at that appellate court of appeals, or if it's at the senator, right? If it's at the Supreme Court level, right? The president's going to pick the person that fills that role, and the Senate is supposed to confirm who's going to fill that role. Now, this process has become highly politicized, right? As Congress does fewer and fewer things, right, over the course of time, as it's become more polarized, what we see is that those presidential picks of who these judges are become more important because they have the ability to check the executive office. So it's become a very politicized process between these two groups, right? Between the president versus Congress as to who gets to become a judge. So it's become very political, and there's a lot of considerations to bring in when dealing with whether or not who should be a judge in this system, right? One of the major considerations is, should judges be impartial, or should they kind of wear their politics on their sleeve? Should we kind of know what they believe about things? I know recently it's become kind of weird to see a Supreme Court justice actually state their positions about politics, kind of prima facie, right, as they're not running, but as they're being nominated to become a Supreme Court justice. And that's actually pretty different than how it used to be. Up until Robert Bork in the 1980s, these justices would say what they actually believed. But then when Bork came into the process and he was very open about his beliefs, it became a very political process, and they had to scuttle his thing. So we've kind of moved to this notion that judges should at least appear to be impartial. Now we know that judges are actually political, but at least there should be some impartiality. They should be observers of the law as opposed to political players. There's also questions over whether judges should be activists. Should they push the law forward, or should they be fairly restrained and let Congress do their job? Or should they defer to the majority of the people, the will of Congress? Or should they exist to be a protector of minority rights, And those activist and restraint don't map neatly onto defer to the majority or protector of minority rights. You can see kind of all these positions emerge from different parts of the political landscape. So it creates a really interesting political landscape out there when trying to get judges onto the court. So this is something that we have to think about, that presidents have to think about when they are picking who they want to be judges, There are good arguments to be made for all of these approaches to making a judge. So these are really things that have to be considered. And really we kind of see a nice sprinkling of different types of judges across the system that kind of fall on all of these different levels of the spectrum. So that kind of presents a bunch of different legal arguments moving forward. So the question for us now is, how do you actually make the Supreme Court work? How does the Supreme Court go about doing its job? Well, this is a 8-step process that really heavily depends on a bunch of outside processes, but to get a court case into the Supreme Court, there has to be this process followed. Before we can even think about getting a formal petition review, or what we call a writ of certiorari, there actually has to be a court case, a real, true, valid case where someone has a grievance that they're trying to see redressed. There has to be an actual person impacted by the law in some way, shape, or form. So there has to be what we call standing of someone, And in order for a court case in order for a case or a piece of legislation to get to the Supreme Court, there has to be someone who's actually been aggrieved. The Supreme Court can't just say, well, we don't like this law, we're going to overturn it before it even goes into practice, Someone has to actually have been affected by some sort of negative law. So they generally have to work their way up through the court system before it even gets there, before it even comes up to the Supreme Court. So that's kind of like step 0. Step 1 is the creation of a writ of certiorari, or a formal petition for review. So once a court case comes out of a circuit court of appeals or a state courthouse or something, we see that the plaintiff has to create something called a writ of certiorari, right, which is an actual formal petition for the Supreme Court to review this case. Now, just because there's a writ of certiorari created doesn't mean that the case is actually going to be granted to be heard. Right? The Supreme Court justices have to go about granting the appeal. Right? Now, the way this happens is based on the Rule 4. Right? That means 4 Supreme Court justices have to be interested in a case in order for it to move forward, to actually grant the appeal. So there doesn't have to be a majority in agreement that the case needs to be heard, but you do have to get 4 justices to agree that the case has merit and should be heard. So the court actually kind of gets to pick its work. It gets to pick the things that it wants to hear, that it wants to see. It gets to really kind of call its own shots here. So once the appeal is granted, right, once they have granted it, right, once the 4 justices have gone about the work of granting the appeal, then comes the point of time where the different parties in the case do what we call briefing the case. Right. So to brief the case, sorry about that. Right. To brief the case, the both sides and also outside parties come together and present, right, what they call briefs, right, summaries of where the case stands at the point where the Supreme Court enters in. And right, all the various legal considerations, previous precedent on a particular case, right, why this case might overturn precedent, why this case is an interesting case, right, what the various considerations need to be for this case moving forward. All the information that the Supreme Court needs to know before, shaking up my drink real quick, right, all the things that the Supreme Court needs to know before they move forward with the case. This can come from the 2 parties, or this can come from within, right? Well, from without the system, right? So what they call amicus briefs or friend of the court briefs. A lot of times think tanks, right, specifically legal think tanks, will file these amicus briefs on behalf of either side of a particular argument. So these briefs go out. The Supreme Court works a little bit differently than kind of your law and order courts, right? The Supreme Court really, right, is trying to decide like kind of theoretical legal merits of issues, as opposed to, right, criminality. So you're not presenting in front of a jury, you're presenting in front of the 9 justices, and they should already, by the time they move into arguments, right, the step 4, the oral arguments, be fairly familiar with the case. So instead of the kind of main juice being the lawyers arguing their sides, right, the process works a little bit differently. Instead, it's the lawyers, right, they do have like 10 minutes to present their case, but then most of the oral arguments are about the justices themselves asking questions of, right, the attorneys, right, the advocates in these cases. So it's almost a little bit reversed from the way you would normally think a court case works, where instead of the attorneys asking questions of the judge, right, the judges ask questions of the attorneys, and they really kind of seek to clarify the thinking and the way that the decision is going to be made. And a lot of times you'll see the 9 justices asking questions to kind of skew and play with other members of the court's opinions. A little bit. Right. So after the oral arguments occur, the justices then retire and meet in conference, where they discuss with each other, right, the merits of the case, what they think, and they really come to a decision at this point in time. They vote, and then from there they go off and they, step 6, explain their decisions. There's always a majority opinion, and there's most of the time a minority opinion, unless, of course, there's a unanimous court case. So what the majority opinion does is that's the official law. This is the interpretation they come up with. That is going to be how the law is to be interpreted moving forward. But that's not the only part of this process. But there were also uh, dissenting opinions, right? That's like, we don't think you're right, and here's why. And this can oftentimes set the stage for future Supreme Court cases, possibly overturning the decision that was made there. There's also the possibility of something called a concurring opinion, which is, you're right, but you didn't do the work right. We don't agree with how you got there. We agree with where you ended up, but we don't agree with how you did it. And this can also set the stage for future Supreme Court cases, right, and future changes in the law. So that really, right, these written opinions really lay the groundwork for things moving forward. If you want, if this is interesting to you, something you might want to look into are the opinions on the Heller versus DC court case. And we'll talk about that one in a bit. But those decisions are very well written on all sides. Clarence Thomas wrote an interesting concurring opinion that really gets into the history of the Second Amendment. That just shows, right, how these opinions can be crafted and formed, and how they can work, right? Concurring, dissenting, majority opinions, all of which in that case are particularly interesting. So if that's interesting to you, go ahead and give that a look. So once those decisions are made and they're written, right, eventually they have to be released, and they're typically released in batches. And this leads to the running of the interns, which is a hilarious event when they actually physically hand out the court opinions, and they have to get to their news agencies or whatever. If you want to see some funny things, look up the running of the interns Supreme Court. Some pretty quality YouTube videos. Because what's interesting is the Supreme Court cannot function on its own, right? It itself is an institution. It's not just the 9 people, right? They each have fairly decent sized staffs and, right, participate in a larger legal system within the United States. So even within the Supreme Court, right, there's the 9 justices of the Supreme Court, but one of those justices has to fulfill the role of Chief Justice. Their job is to kind of herd the cats, if you will, of the Supreme Court to get them towards finalized opinions. Let's pull up a little bit. I don't know. The green screen keeps popping in. So the Chief Justice is really the justice who's responsible for the most institutional functioning within the Supreme Court. It's his job to keep the Supreme Court functioning and, right, kind of direct things. And each justice of the Supreme Court also has clerks who really help them write opinions, do research, write, particular briefs for each case to help the Supreme Court justices understand what the important arguments are. They really just help the Supreme Court do its work, and help the justices make opinions and do their work. Right, so right, the clerks are the ones that really kind of sit in chambers, argue with the justices, really help the justices craft their opinions, and then they go on to help write those opinions and do the research and all the kind of clerky sort of things. I know that's redundant to define it with itself, but they literally are clerks for the Supreme Court. We also see, right, 2 particular big roles fulfilled by the Justice Department, right, representing the executive branch. We see the Attorney General, whose job is to really be kind of like the country's chief prosecutor, and oftentimes serves in a very strongly, closely tied role to the president. The Attorney General is kind of the big rock star, runs the Justice Department. But one of the more important roles that we don't hear about as much is the Solicitor General, right? This Solicitor General is the country's chief defense attorney, right? He's the one that goes, he or she, right now it's actually a she, goes and defends the country in court, right? And they both have large staffs that sprinkle down through the entire 94 court district courts within the country. So there's both solicitors and attorneys, U.S. district attorneys, attorney general, right, prosecution versus defense that exists throughout the whole system. Right. So in large part, the way that this system functions is based on a lot of these amicus briefs, right? They really provide a lot of the legal background to assist the Supreme Court in getting their job done, right? Giving them the different ways that they could potentially go against stare decisis, which is that next term there. Stare decisis is the legal term, right, and the legal principle that precedent matters, right? In the overall legal system that we have here in the U.S., right, we are predicated on what's called civil law. The United States, right, doesn't really write down every particular opinion about law for every particular thing. We generally let our precedents, right, what we've done in the past, stand, right, throughout time, right. So it's really difficult to overturn precedent. So that's right, really how most of our legal system functions. Now, here in Louisiana, we don't have a civil law in that form, right? We have codified law, meaning we do write every damn thing down. So right, that difference is important, right? But overall, right, our legal principles and traditions lean towards defending, right, precedent and tradition. Now, if we wanted to, right, if we wanted to manipulate the court, right, the Supreme Court, or at least the federal courts, there's not a whole lot of constitutional direction saying what they should be like. So we could theoretically, right, as a population, decide to add more Supreme Court justices, right, or change the way that the Supreme Court functions by really parceling out kind of the jurisdictions of the court, right? So change the number of people on the court, change what the court is actually allowed to do, right? Those are all things that Congress could do to change the court in some significant ways. But for the most part, we've settled on 9 Supreme Court justices. 9's a nice round, odd number so that you don't get a whole lot of ties. And right, it seems to do a pretty good job as a generalist sort of court. But that doesn't mean that we couldn't change these things moving forward, right? And that's started to become part of the political conversation, is, you know, manipulating the Supreme Court. Right? As it's become more and more politicized, as the president receives more and more power, the court also becomes much more powerful. So as a check to the president, right, the office of the executive. So that you see a lot of, right, hand wringing about maybe we need to change the courts to make them more responsive to the will of the people. And that's something to think about moving forward. Now, I say 11 court cases that made America, but we're actually going to talk about 17 of them. Right? These are the major court cases that exist that have defined our rights and our relationship with the government. So we're going to look at these 17 court cases and see, right, how our rights and laws have changed over time. No. Tripping on myself. So the firstliest of all of our court cases is Marbury versus Madison. This is a case that really established the ability of the Supreme Court to conduct judicial review, to actually review the constitutionality of laws. Prior to Marbury versus Madison, it wasn't 100% clear that the Supreme Court could do this. But in the case of Marbury versus Madison, they decided that yes, in fact, the Supreme Court can do this. So they essentially granted themselves the power to do judicial review, which sounds a little weird, but right, you have to have, right, when there is no precedent, you have to somehow create a legal justification for doing things. So the Supreme Court had to do that. So number one, Marbury versus Madison gave the Supreme Court the ability to conduct judicial review. Number two, McCall versus Maryland, which we have already talked about in this course, establishes, right, kind of the relationship between the federal government and the state government, creates the supremacy clause, really changes the relationship between, gives the federal government a whole lot more power, essentially is what it does. Number three, Dred Scott versus Stanford. Right? This is the court case that enforced slavery, right, across the Union. Right, this really set the stage for the Civil War. Showed that, right, that these property rights carried across state boundaries. Really sets up the politics of the Supreme Court, of the Civil War, and really establishes that sometimes the Supreme Court gets things wrong, and that the Supreme Court can undo a lot of precedent, which is really what a lot of the story moving forward is going to be. So number four, Santa Clara County versus Southern Pacific Railroad. This one really isn't all that important, except it does one thing that's really important moving forward. Right? Santa Clara County versus Southern Pacific establishes that corporations, because they are made up of people, have the same rights as people. So corporations are people, and therefore have the same rights as people. And that's a weird court case from like the 1850s. It really shouldn't be all that important, but it will be later on, so keep that one tucked back. After the Civil War, right, we see, right, kind of a shift towards granting, right, the Supreme Court shifting towards understanding the boundaries of rights within our country and really using the 14th Amendment of the Constitution to apply kind of the rest of the Bill of Rights at the state level. Sorry. I guess I'll have to hang out this direction. Right, really establishes at the state level this right, individual rights. So number 5 sees Plessy versus Ferguson, which establishes the separate but equal doctrine, which will be torn down by the next court case. Number 6, Brown versus the Board of Education, under which there is no more separate but equal doctrine. They realized they got that wrong. It took them about 50 years, but they undid it. Number 7 gives us Gideon versus Rainwright, which says that you have the right to an attorney. If you're accused of a crime, you have the right to an attorney to a legal defense. That's Fourth Amendment being applied. Virginia versus Loving allows for marriages across race. This really undid a lot of law is saying you couldn't do that. I'm sorry, I totally punted on that word. Anti-miscegenation. Nope, I can't pronounce it. Sorry, it's not happening today. But interracial marriage, totally legal. The government doesn't have a right to say you can't do that, especially at the state level. Number 9 is Miranda versus Arizona, establishing the Miranda warning, right? The rights that you have if you're accused of a crime. You have the right to remain silent. Anything that you say can and will be used against you in a court of law. You have the right to an attorney. Should you not be able to afford one, one will be provided for you by the state. Those are your Miranda rights. If you ever get arrested, you're going to hear those. And if you don't hear those, that's a violation of the Constitution. You have the right to that. So remember that. I just remember that if you're wanting to invoke the Fifth Amendment, you actually have to say something that you're not going to self-incriminate. You're going to use your right to remain silent, and you don't say anything. Now, mind you, I'm not giving you legal advice there. I'm not a lawyer. But that's an interesting one you need to know. Number 10 is Griswold versus Connecticut, where it was established that you have a right to privacy. That the Fourth Amendment actually establishes that you have a right to privacy within the United States. This wasn't necessarily there, right? The right to privacy isn't explicit in our Constitution, but Griswold versus Connecticut helps establish that. Number 11, Roe versus Wade. Yes, both Griswold and Connecticut and Roe v. Wade are cases about abortion, but they also establish larger legal rights. Roe versus Wade says that you have the right to bodily autonomy. You own your body, which is a pretty fundamental, important thing to know. That I am bodily autonomous. I own my own body. I can do with it as I please. That's really important, especially when paired with the right to privacy, which will come in later with some other interesting cases. Number 12, Lemon versus Kurtzman. You might have heard of the Lemon test. This is actually referring back to this law, and this is a law that establishes the boundary, right, and how to know, right, where church and state can work together and where they can't, right? If it fails what we call the Lemon test, then it's a failure of the church and state, right? Failure of separation between church and state. So this really helps to clarify how that works out. Number 13, Chevron USA versus National Resource Defense Council creates what we call Chevron deference. And this is the legal principle that bureaucrats get to interpret laws. And the courts are going to allow bureaucrats to interpret laws basically as they see fit. This one's real controversial. Probably going to see some court cases in the next few years trying to undermine this Chevron deference, especially with the way the court's composed right now. Number 14, Heller versus DC. I already mentioned this one. But what this one established is that individuals have a right to the use of handguns. And this is really an extension of the 14th Amendment, using the 14th Amendment to apply the Second Amendment to the states. And really has some good, interesting decisions, right, different findings across, right, the majority, the dissent, and the cooperating, right, the cooperating ones. So it's a really interesting court case, and right, really helps to show how the 14th Amendment applies the various Bill of Rights to the people. Number 16, Citizens United versus the Federal Elections Commission. But this has to do with campaign finance laws, which are real boring, but builds on the notion that corporations are people. Right? And it also established this notion that money is speech. So if money is speech, right, a First Amendment right, you have a First Amendment right to use your money as you see fit, because that's a speech right. And if corporations are people, then that means corporations have a right to use money as free speech. Really vastly changing our electoral system, pumping a whole lot more money into the system. We already talked about this during election, right? When we talked about voting in elections a few modules back. But this court case really expanded that role and allowed for kind of political action committees and super political action committees to throw a whole lot of money into politics. Right. So that was number 16. Number 17 is Kelo versus the City of New London. Now, this one does things about eminent domain, and I think this is one of those court cases that's going to get revisited as well. And I kind of want to put it on there for something y'all can watch a little bit more moving forward. But what Kelo versus City of New London established is that the state has the right to take people's property if it's for the public good. Now, I'm going to tell you a little bit more about this case. City of New London wanted to buy Kelo's house and turn it over to a land developer to build a mall, using eminent domain to say, hey, well, we'll be able to get more tax money off of this, right? We should have the ability to do this. Well, court case gets drawn out, right? Takes years, goes to the Supreme Court. They eventually find that, yes, City of New London can use eminent domain to take Kelo's house and turn it into, basically a strip mall. But here's the funny thing. City of New London never built that strip mall, so they did this big case, took this person's land, and never did anything with it. So I imagine we're going to see that get brought up. There was a pretty strong dissent that said that this was misfound. So I imagine we'll see this one crop up again. Now, what those court cases did is essentially establish our rights, our liberties, and our entitlements within the United States. And these are three very separate but often conflated, right? We get them mixed up concepts. So we need to go into a little bit about what each one of these really truly establishes. So rights, liberties, and entitlements are all very different things. A right are the things that we are able to do, right? The government actually helps us to do these things. So these are things like voting or getting an education. Right? The government actually helps us to go through this process. Right? They help enforce these rights, make sure they are not kind of stepped on. Liberties, on the other hand, are the things that we are free to do, and the government actually protects us, right? Protects us from these being impacted, right? So these are things like speech and expression, and all this kind of First Amendment rights, freedom of religion, right? Our freedom to protest, get together with our friends, right? Do what we want, right? Liberties are things we are free to do. They're like things that the government serves as a shield to protect us from, right? Imagine Captain America's shield, like protecting us. Whereas rights are like the government lifting us up, like lifting up a baby to, grab something off the shelf or something. Entitlements, on the other hand, are things the government actually gives to us, right? So we kind of have a right to education, and the government actually gives one to us. Right? The government can give us health care. The government can give us social safety net things. The government can give us roads. Right? All these things that the government gives us, right? They're typically physical goods. So a right's an action, a liberty is something we're protected from, and an entitlement's a physical good that we are given. So knowing the difference between those three different things is going to be very important here. So there's a question about where rights actually come from. There are many different interpretations of where we get our rights and what rights actually are. So one thing that was introduced by those Enlightenment liberal thinkers that we talked about in the early days of this class are the notion that we have things called natural rights. These are rights that we as humans have because we are human beings. Right? These are granted to every human equally, or they should be. Right? We possess these. Right? These are the things that make up our own human dignity. These are rights that are granted by providence. These are moral rights, inalienable rights. These are the right. When someone says my God-given rights, these are what they're talking about. These are rights to life, liberty, the pursuit of happiness, right? The ability to own things, the ability to defend ourselves. These are the rights that we have because we are human, right? Which are different than the so-called legal rights, rights that we have given ourselves or that we give collectively, right? These are the laws that are granted and decided through the policy-making, law-creating process. These are the right for everyone to be treated equally. These are the rights for an education, right? Everyone, right? These are the rights that we as a society agree are important, not the rights that are inherent within us. There's also positive and negative views on rights, right? So a negative right is a right where you're protected from everyone else, right? From other people's actions and the state's actions. So these are like freedom of speech, freedom of assembly, freedom of the expression of religion. We're protected from other people stopping us from being able to use these rights. Whereas a positive right is something that we are given or granted. Right to an education, right to vote, right? These are positive rights, things that we're given. Right to health care, right to food or whatever. These positive rights are the ones that are given unto us. There's also a big question about where rights apply. Like who actually gets rights? Is it individuals or is it groups? Right? If you give rights to individuals, then everyone can have them. But if you give rights to groups, right, then kind of identities can be expressed and protected. So this is a very open, ongoing debate. Most of our kind of current politics is about this last point, about who really gets rights, right? Who rights are to be provided to. So that's really important. That's something to think about, right? We don't normally think about where rights are centered or located, but that really has a kind of fundamental impact on how rights get applied. I'll kind of leave it up to you to think a little bit more about who actually should receive rights. So I'll leave that there for you. So we talk about all these rights, but what rights do we actually have? What rights are granted unto us? Which rights are human rights that are protected by the government? This is really important to think about. And right, our rights come in the Constitution, and they come from really two parts of the Constitution. We have our first rights, which are the rights in the Constitution as originally written. And these are mostly like protections from abuses of power by the state. So we have things like the writ of habeas corpus, which means we have the government has to actually have a reason to detain people. They can't just arrest you for no reason. They have to have an actual crime that they're charging you with in order to hold you, right? This is the whole Law and Order. We can only hold them for 24 hours unless we actually charge them with a crime sort of thing. That's the writ of habeas corpus. There actually has to be a claim that you have committed a crime in order for the government to hold you. At the same time, right, we also don't have bills of attainder in our government, which means, right, you can't be punished without having first been put on trial. Right? A bill of attainder is like, punish this man. You actually have to be tried first in order to be punished for something. They can't just throw you into jail. Right? You have to actually have sat through trial or at least a plea deal in order to go to jail. The government's not allowed to create ex post facto laws. Right? They can't make something a crime after you already did it. Right? You have to have, in order for something to have been a crime, they have to have made it illegal before you did it. So sometimes people can get away with like really weird law, right? Really weird things because there was not a law, right? So you hear about those like really weird laws, like no eating ice cream while riding backwards on an elephant on Sundays. It's because somebody did that and they got off of law, and then they wrote a law about it saying no, you can't do that. There's none of this. You just can't do that law, right? You actually have to have said that something was illegal beforehand, right? So no ex post facto laws. You're also not allowed to have titles of nobility, right? Now, this is the government saying you can't do something, but it also is a fundamental thing to make sure the government applies laws equally. Right? No titles of nobility means that we are all on an equal playing field from a purely legal perspective. Okay. Which is also why you see people like Princess Meghan Markle, right? Princess Meghan, right, has to give up her American citizenship in order to become princess. But she can't be above the normal people, right? In the United States, we're all the same. Now, there might be socioeconomic differences, but there is no legal difference of class. Right? That's just not a thing. So no titles of nobility. Unfortunately, there will be no Sir Dr. Gilly. But on the other hand, that means I'm entirely politically and legally equal to each and every one of you. Peasants. Can't do that. We're all peasants. We're all citizens, comrades. All right. There is also the protection of citizens as they move between states. There's a large deal of freedom of movement between states granted by the Constitution. You shouldn't have to show identification to move between states. There's no border checkpoints between states, right? If I were to get in my car right now and drive to Texas, I just keep on driving. There is freedom of movement. And our rights also transfer between states. Now, they might be slightly different rights between states, but those rights do, in fact, transfer, right? You're given the same citizen rights, right? The rights of a citizen. If you're from Louisiana, you have the same rights of a citizen in Colorado or California or Wisconsin. Now, those specific types of rights might be different, but you are granted all those rights, immunities, privileges, etc., etc. Also in our Constitution, this one's interesting. You can't use a claim of treason to punish other activities, right? If you're going to claim treason, that's its own thing, and you definitely can't use treason to up the costs of other crimes that have been committed. Treason is its own charge, and there are limits to the punishments for treason. Now, you can still be put to death for treason. That's absolutely still on the table, but you can't be tarred and feathered first, right? There's limits to what they can actually do. In our Constitution, there's no religious tests for oaths of office. So you can't be made to swear on a Bible. You can't be made to prove you're a Christian or a Muslim or a Jew or whatever. That's simply just not in there. Anyone should be able to serve office. It doesn't matter what religion or no religion that they have, right? That's built in there. And there's also a lot of protections built into our Constitution, saying the government can't interfere with private contracts, and that's a pretty damn big deal. That we as individuals are allowed to contract with each other. We have a right to contract, and the government can't really get in and say, no, you can't really do that. If it's two private individuals, they can contract for a whole lot of things, as long as it's not breaking the rest of the laws. And then you get RICO charges, racketeering, corruption, that whole deal. But for the most part, there are some pretty heavy protections of individual contracts between individuals. Now, those are some pretty strong rights, but that's not all the rights that we are granted. One of the big early debates in our Constitution is, should we lay out rights for individuals in the thing, right? And James Madison argued, no, we don't need to put them in there. It's fine, right? We've given a whole lot of rights here. Everything else is kind of assumed, right? The powers and abilities, if it's not granted in the Constitution, it's granted to the citizens. So if we didn't say they can do it, they don't need to be told that they can do it, right? It's already there. There was a lot of disagreement over that. So James Madison also wrote a Bill of Rights, right? The first 10 amendments to the Constitution, and then several other rights that followed on along from that, and basically served as like a day one downloadable content for the Constitution, passing at the same time, establishing a lot of rights for individuals within this system. Particularly the First Amendment, right, does a whole lot, right? It establishes freedom of religion, freedom of speech, freedom of press and assembly, the right to petition the government, right? All of that exists within that First Amendment. We're also granted property rights and due process rights, privacy rights, criminal suspect rights, right? There were a whole lot of laws and individual rights granted in those first 10 amendments, and then additionally with the 14th and 15th Amendments. Gives a whole lot of protection. What we see is that, especially because of the 14th Amendment, there is supposed to be equal protections under the law, basically for everyone. If you're a United States citizen or you're in the United States, you are given equal protection under the law, right? And you have to follow due process in order to undo those protections. So our law really does apply fairly widely. Now, perhaps that's not good enough. Perhaps we need to make everything very explicit, right? That's this notion of the Equal Rights Amendment. But there are a lot of things that go into this, right? And the 14th Amendment really heavily applies individual rights across the states. And just to also make things more clear, right, we passed the Civil Rights Act and the Voting Rights Act in the 1960s to really clarify that, hey, equal protections under the law, the ability to vote, right, these things are really heavily ensconced in further laws and then apply throughout the nation. So we have a whole lot of rights, we have a whole lot of entitlements, and we'll talk more about entitlements next module when we look at the policymaking process. But we have rights, they're protected by the judiciary. That's what the judiciary exists to do. So that kind of covers our three module character arc, our three module arc about how we govern the United States, right? How we built our institutions. So if there are any questions, please feel free to hop in the Discord, shoot me a message. I'm here to help clarify things. So thank you for watching, and I'll see you next module where we get into the actual policy making process. So thank you and have a great day.